Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to Mississippi versus Carly Gregg. She had an appeal hearing yesterday. We are going to take a look back at her trial, her verdict, and then we're going to go ahead and jump into her appeal. So let me check my audio.
Thank you so much.
Audio is good. All right, so get comfortable, settle in, and let's get started. All right. Good morning, everybody. Welcome in. Hope everybody's doing okay today. Let's see who is with us. We got Kimbers. We have Snap. We have Green-Eyed Cat. We got Good Vibes. Hello, hello. Welcome in. Hey, Hell Rider. How are you today? Shore Life Creations. Good to see you. Allison, good morning. Deviant and Tammy, good morning to you. Yes, it should be interesting. I'm looking forward to it, Hell Rider, for sure. Heidi, hello to you. Good to see you. Wizard of Ezzy, welcome in. Camilla, good to see you. JMS, Scent Bunny, good morning to you both. Iowa Backyard Cam, hello, hello. Beach Mom, going to catch us on your morning walk. Sounds good, sounds good. Let's see who else is with us. Fanny, good morning. Good to see you. The Pretty Chick, hello, welcome in, welcome in. Lisa, good to see you. Bama Green Eyes, good morning. Little Lulu, nice color of the shirt. Yes, it's very vibrant. It's much more vibrant. I guess it's salmon, right? Would you consider this salmon? Nick Wilson, good morning to you. Mary, good to see you. Green-Eyed Cat, can't tag anybody. Oh, good morning to everyone I didn't tag, sounds good. Snap Music as scary as she is. Hey Barry, how are you? Talking about Florida PI Sam's stream this Saturday. Yes. Hector's mom, Mal, good morning and welcome in. Good to see you guys. Jane, good morning to you. All right. Making Clay, good morning to you. Thank you for joining us. All right. So let's get settled in. Let's wrap our head around this again. So this was one of the trials that we covered way back when, but we had to take it down because it was before I was on screen and YouTube demonetized us. So we had to actually take down all of our trial. we actually showed this trial, but we had to take it down. So we're going to go back and revisit it. So Ashley Smylie is the victim. She was 40 years old. Carly Gregg, she is the defendant. Let's see, was she 14 at the time? We have 14. Yeah, she's 17 now, so she was 14 at the time. So this took place March 19th of 2024. Her charges were first degree in the shooting and death of her mother, Ashley Smylie, attempted murder, sometimes reported as aggravated assault and appealed coverage for shooting her stepfather, Heath Smylie. Now he survived. She shot at him and he survived. And then tampering with evidence related to actions after the shooting. Remember, she called her friends to come over, say, hey, do you want to see a dead body? All of that. Excuse me. So the judge is Dewey Arthur, prosecution's Catherine Newman, and the defense is Bridget Todd and Kevin Camp. And now for the appeal, it's James Murphy. So prosecutors allege that on March 19th of 2024, 14-year-old Carly Gregg shot her mother, Ashley Smylie, 40, twice in the face and once below the chin before inviting a friend over to view the body. Ashley Smylie was a high school algebra teacher at the same school her daughter attended, Northwest Rankin High School. This is in Mississippi. According to police, Ashley's husband, Heath Smylie, arrived home to find his wife on the bedroom floor. Gregg was in the kitchen where she allegedly fired at him approximately 3 times, hitting him once in the shoulder. Heath managed to wrestle the gun away from her, after which Gregg reportedly fled through the back door and jumped over a fence before being apprehended about a half a mile away. Now, after this happened, Gregg allegedly used her mother's phone to text her stepfather asking when he would be home, and sent a message to a friend from her own phone claiming an emergency and asking the friend to come over. When the friend arrived, a detective testified that Gregg asked if she had ever seen a dead body. When the friend said no, Gregg showed her mother's lifeless body and reportedly told her that she had fired 3 times at her mother and had 3 more prepared for her stepfather, 2 to the head and 1 to the chest. The friend then left the home as Gregg waited for Heath to return. Now, there's also, she was taking pharmaceuticals. So she was on medication, and she had switched, like she had stopped taking one med and switched to another med or something like that. There's all of that. So we're going to have to, we'll get into that as this progresses. So, Surf and Selena, good to see you. Hey, Fanny. Sad case, this young lady needs to stay out of society. Richard in the kitchen, good morning to you. Let's see. Renee, good morning to you. How are you? All right. I think I got everybody. You watched the original trial. Hope they keep her in prison. Yeah, well, we watched it, and do you remember the ring? What was it? Was it Ring video or whatever the video they had of her in the kitchen, and she was like singing and right. She was looking up at the camera. It's all pretty chilling stuff. All right, so first we're going to start off with opening statements. We're just going to kind of get back into this trial. So we have opening statements, and then we're going to listen to her verdict and her sentencing, and then we will get to the appeal. Okay, hold on a sec. Let me just grab this, move this around. All right, so let's get to her. So that's the backdrop. So let's get to her opening statement so we can kind of understand. I want to kind of get back into this. So let's get back to her opening statement. Sorry about that, guys. All right, so this is opening statements.
Ladies and gentlemen, you have been seated and properly sworn as the jury to hear this case. The court will now give you what I call a preliminary instruction, and I ask that you pay close attention. As the trial proceeds, I may ask you if you have followed these admonitions. You are not to discuss among yourselves any subject connected with the trial until the case has been submitted to you for deliberation. You are not to converse with anyone else on any subject connected with the trial until you are discharged as jurors in this case. You are not to permit yourselves to be exposed to outside comments or news accounts of the proceedings until you are discharged as jurors in this case. You are not to conduct any independent research about this case, the legal issues, and or the parties involved. You are not to view the place where the offense was allegedly committed. You are not to form or express any opinion on this case until it has been submitted to you for deliberation. You are not permitted to mix and mingle with the attorneys, parties, witnesses, and spectators, and you are to avoid all contacts with those persons. You are required to report to the court any communication or attempt to communicate with you on the case or any subject connected with the trial. You may not take notes during the course of the trial. There are several reasons for this. It's difficult to take notes and at the same time pay attention to what a witness is saying. Further, in a group the size of yours, certain persons will take better notes than others will, and there's a risk that jurors who do not take good notes will depend on jurors who do. The jury system depends upon all jurors prior to the trial. Upon the other rule is
May I proceed, Your Honor?
yes, ma'am.
This is a case about Carly Madison Gregg. Carly Gregg has been charged with murdering her mother, Ashley Smylie, and attempting to murder her stepfather, Heath Smylie. She's also been charged with tampering with physical evidence for removing a camera and hiding it that captured a portion of the events. Ladies and gentlemen, you'll hear testimony throughout the next few days during this case. You'll hear about some secret life that Carly lived. You'll hear that Carly had a secret boyfriend. You'll hear that Carly had a secret iPod, that she had secret social media accounts that she was using to communicate with people on this iPod when her parents had taken her phone away. You'll hear that she was secretly cutting on her thigh using a knife. You'll hear that she secretly had burner phones her mom and stepdad didn't know about that she was using. You'll hear that she had secret weed vape pens and that she before going to school at times. Ladies and gentlemen, that's not why we're here though. We're here because of what she did on March the 19th, 2024. That you'll hear that Carly is the daughter of Ashley Smylie, the stepdaughter of Heath Smylie, that Heath and Ashley were married sometime in 2020. You'll hear that Carly's not been in her life for about a year or more, that he was a known drug user, had violent and angry tendencies. You'll hear that back in January, Carly got in trouble with her parents when they found this iPod, that they got onto her for using these secret accounts and for communicating with people. You'll hear that around the same time that she had this boyfriend they found out about, and that they asked her to break up with him, and that later they found out she was still seeing this boy. You'll hear at some point that Carly got in trouble at school. She was cheating. She'd found the answers to a test and gave them to the other students. You'll hear that all of this was happening about the same time that they found out Carly was cutting on her legs. You'll hear that as a concerned parent, what they did was they got Carly in therapy. She was being treated for anxiety and stress. You'll hear that she continued smoking those vape pens even after in therapy. So now I want to take you to the real reason we're here and what you'll hear. We're here because on March the 19th, 2024, Carly rode to school with her mother that day. Ashley was a school teacher at Northwest Rankin, taught geometry. Carly was in the 10th grade. You'll hear that morning she got in a little altercation with one of her friends, cussed him out. But what you'll hear, ladies and gentlemen, from the testimony of this friend is that he was so worried about Carly's use of smoking marijuana, and so worried about her being high, and so worried about her having these burner phones that her mom didn't know about, that he felt compelled to tell Miss Ashley Smylie that day. Ladies and gentlemen, after the incident with Carly that morning, you'll hear that he gets in touch with another friend and he's like, hey, you got to keep her distracted so I can go tell Miss Smylie what's going on. Ladies and gentlemen, this friend cared about Carly. He was like, I gotta intervene. I gotta tell her. I'm afraid of what's happening. You'll hear from him that he did in fact tell Miss Smylie. That after 4th block that day, he goes and he tells Miss Smylie, hey, Carly has got these vapes. She's got this phone. Ladies and gentlemen, you'll hear then that Carly Gregg rides in the car home with her mother from school to their house. They leave school sometime after 3:30. They get home a little before 4. You'll hear that when they get inside the house, it's only their 2 dogs, Ashley Smylie and Carly Gregg. Immediately, Carly goes and lets the dogs out. You'll hear testimony that Ashley then goes into Carly's room. You'll hear that while Ashley is in her room, that Carly's still outside. At some point, Ashley finds what law enforcement believe to be the 4 boxes that contain vape pens. Testimony will be that we believe she carried them from Carly's room to her bedroom, went back to search in Carly's room. The evidence will show that almost immediately upon Carly coming inside the house, that she walks straight to her parents, goes straight to her mom's side of the bed and removes a .357 Magnum from under the mattress. We believe the testimony will be that then she concealed that .357 Magnum behind her back. As she walked through the kitchen, she peeks her head around. We believe the testimony will show that she peeks her head around the kitchen to make sure that her mom hasn't come out of her bedroom. We believe the evidence will then show that she walked with that .357 Magnum behind her back, walked in to her own bedroom, and then fired 3 shots into her mother, killing her. We believe the testimony will then be that that very moment after she shot and killed her mother, she then hides that gun back out of the camera, walks back into that kitchen, sits down on a stool with a gun behind her, picks up her mother's cell phone, puts her mom's passcode into the phone. We believe the testimony will be that then she texts her stepdad and said something to the effect of, "When will you be home, honey?" Testimony will be that then she waited for him to respond. "I'll be a little bit longer." She sends him a thumbs up. Ladies and gentlemen, we believe the testimony will then be that after she puts the phone back down and walks out of sight with the camera, that between the next 45 minutes or so, that the defendant reaches out to or attempts to reach out to about 5 or 6 of her friends. Some were FaceTime, some were text messages. We believe the evidence will show that during this time she was asking them all for help, trying to get them to come over to her house. She wouldn't tell them why. We believe that one of them's going to say he even offered to call 911 and she told him no. The evidence will also be that one of these friends did in fact come over to help Carly that day. She didn't know why, but she knew that her friend needed help, and she went to that home. We believe the evidence will show that when that friend arrived at Carly's house, that Carly walked to the front door, asked her, "Are you squeamish around dead bodies?" We believe the evidence will show that then she took that friend and showed her dead mother laying on the floor. We believe the evidence will show that after that, she says, "I put 3 in my mom, and I got 3 more waiting for my stepdad when he gets home." We believe the evidence will show that then she tells this friend, "Hey, why don't you go wait outside in the backyard? My stepdad's about to be home." This friend will testify that she does go in the backyard and she hears gunshots. And the next thing she sees is Carly coming out of the back door. We believe the testimony will be that she fell down coming out of the back door, gets up and tells her to run. And these 2 individuals, this friend and Carly, jump over the fence and run separate directions. You'll hear testimony that there was a 911 call. You'll hear a frantic Heath Smylie telling the dispatcher, "Oh my God, she's killed her mother. She hit me in the neck, it grazed me, she tried to kill me too, she's run off." You'll hear from law enforcement when they arrived on the scene that Carly Gregg had fled the scene. You'll hear from law enforcement that when they arrived on the scene, Ashley Smylie was very much dead in the floor in Carly's bedroom, and that they found that Heath Smylie had been shot and hit in the shoulder, through and through. You will hear from law enforcement that sometime after the day of the event, they learned that there was cameras involved, that this home had surveillance video. You'll learn that one of those videos was turned over by the living victim, Heath Smylie, and it shows Carly Gregg and her friend jumping over the fence. And then you'll learn that there was another camera in the house on March the 19th, 2024. That Carly was hiding the gun out of sight of. And you'll hear that that camera was not in the kitchen when law enforcement got there, and it was not in the kitchen where it should have been when Heath Smylie got there. It wasn't until sometime later that that camera was discovered. Ladies and gentlemen, you will hear that Ashley Smylie's cause of death, gunshot wounds to the head. Ashley Smylie's manner of death, homicide. You will hear that Heath Smylie says, Carly Gregg is the one that shot at me. And on his 911 call, he said that she tried to kill him. You'll hear him say that he did not move that camera, the only other person living in the home. Ladies and gentlemen, you also hear from forensic scientists from the Mississippi Forensics Laboratory. You'll hear that both of Carly Gregg's hands tested positive, both the right and the left. You'll hear that the .357 Magnum that was used to kill her mother and shoot her stepfather, they took swabs. They took a swab of the trigger and they took a swab of the hammer. And you will hear that the DNA profile that matches those swabs belongs to Carly Gregg. Ladies and gentlemen, you will also hear that there were 2 projectiles removed from Carly Gregg's mother, Ashley Smylie. One in her brain, one in her neck. Projectiles were tested with ballistics, and that those projectiles matched the .357 Magnum that Heath Smylie took out of Carly Gregg's hand that day on March the 19th, 2024. And ladies and gentlemen, at the end of this trial, after you've heard the evidence, the state will stand before you and we will ask that you murder, attempted murder, and tampering with physical evidence. Thank you, Your Honor.
Does the defense wish to make its opening now, or do you wish to defer?
The defense will go ahead, Your Honor.
Opening statement by the defense.
Good afternoon. I know it's been a long morning for you all, so I will try to do this as briefly as possible. This is not a whodunit case. We know who took action on March 19th to bring about the death of Ashley Smylie and the injuries to Heath Smylie. However, this is a why case. Why did it happen? Why did this exceptional child with no history of violence, who was loved by her friends, her teachers, her parents, who had a good home life, who loved her mother, why did she shoot her mom? Why did she shoot at her stepfather? The state would like you to believe the answer to those questions don't matter, but we know better than that. The answers to those questions is why we're here today, and it's what you're here to do. We believe the evidence will show that there were 3 victims on March 19th. Ashley Smylie, Heath Smylie, and Carly Smylie. And Carly Gregg. That they were all 3 victims. We believe the evidence will show that Carly had been suffering from a mental illness, that Carly was not aware on March 19th that she had a mental illness. We believe the evidence will show that Carly's parents, who lived with her, were not aware that illness. We believe the evidence will show that Carly's close friends, who saw her at school every day, were not aware that Carly was suffering from a mental illness, because it's hard to look at a person and understand that they have a mental illness. It's hard to look at a person and know that they have a mental illness. That's why it's often referred to as the invisible disease. A person can exhibit symptoms of a mental illness without people necessarily knowing that they have one, or other people necessarily knowing the person has. While the events on March 19th were tragic, the events on March 19th were not intentional. The evidence will show, and the testimony will show, that Carly Gregg loved her mother. That Carly Gregg and her mother had a loving, close relationship. Carly Gregg's mom loved her. In fact, her life revolved around Carly, as parents' lives often do revolve. Carly Carly very much wanted to please her mother. Carly was an exceptional student, made a 30 on the ACT when she was 13 years old. She was the apple of her mother and her stepfather's eye. And you will understand by the conclusion of this hearing why Carly's stepfather is standing behind her. Because he knows on March 19th, there were 3 victims: Ashley, Heath, and Carly. The state will ask you to take your good judgment, to take your common sense, and to put it in a bucket, to put the lid on the bucket, and to toss the bucket out of this courtroom. We implore you not to do that, to retain your common sense, to retain your good judgment, and to make sure that you are listening to the evidence as it's presented, because it doesn't matter how many witnesses the state puts on, their story is filled with inconsistencies because they're not telling the whole story. The evidence will not show that Carly was ever deemed dangerous by anyone. The evidence will not show that Carly ever had any desire to hurt her mother. The evidence will not show that Carly ever had any desire to hurt any person. The evidence will not show that Carly invited people over to her house to view her mom's body. What it will show is that on March 19th, a hysterical Carly called her closest friends, begging them for help, begging them to help her. The evidence will show that Carly did not recognize Heath Smylie when he got home that day. You'll hear that from him himself. The evidence will show that Carly was so terrified when Heath Smylie got home on March 19th that even after Carly left the house, Heath walked around the house with the handgun in his hand looking for an intruder because he was convinced by Carly, by how she appeared, by how she acted, did that day, by the child he had known for years, that she was terrified, something in that house to cause that kind of terror in Carly. What the evidence will not show is that Carly had a drug problem. What the evidence will not show is that Carly and her mother had any argument on March 19th. What the evidence will not show is that Carly had any desire to hurt her stepfather. What the evidence will not show is that Ashley Smylie was angry when she left school that day, or that Ashley Smylie was upset with Carly when she left school that day, or that after they got home on March 19th, Ashley and Carly engaged in an argument. The evidence will not show that Ashley Smylie found anything in Carly's bedroom that would have caused an argument. The evidence will not show that Carly intended to hurt anyone. The evidence will not show that Carly has not grieved her mother's loss. The evidence will not show that law enforcement did their due diligence in investigating this matter. The evidence will not show that Carly was abusing or misusing prescription medication. The evidence will not show that Carly was just a teenager who had a life that her parents didn't know everything about. That's called having a teenager and being a parent. The evidence will not show that Carly had ever tried to harm another person, had ever had a desire to hurt another person. The evidence will not show that Carly is a monster, that Carly was a difficult child, a troubled child, or a deranged child. The evidence will not show that Carly Gregg does not deserve you to return a verdict of not guilty. Now, the evidence will show that Carly had a family history of mental illness. In fact, it was well documented. The evidence will show that Carly was concerned that something was wrong with her. She wrote journal entries about it. The evidence will show that Carly was afraid she had the same mental illness that her father had. The evidence will show that Carly's mother had worried for years about Carly having the same mental illness that her father had. The evidence will show that Carly was very emotionally tied into her mother's emotions, and that Carly never wanted her mother to worry about her. The evidence will show that Carly was scared of how her mother would react to the knowledge that if Carly had the same mental illness that her father had. That doesn't sound like a child that doesn't love her mom. And that doesn't sound like a child who has any intention of hurting her mother. The state would like you to believe that it's normal for her to go home from school one day with their mother, who they love, and shoot her, but nothing's wrong. It was just marijuana. Or because she was on social media and her mom didn't want her on social media. But again, we ask you to retain your common sense and to retain your good judgment, because we know that just doesn't make sense. And at the end of this trial, if the state's case still leaves you feeling like their version of events just doesn't make sense, then you must return a verdict of not guilty.
All right, so those were openings. So now I want to get to the video so we can play this video. So this is the video of what happened that day. Let me come over here. And then I'm going to play Heath Smylie's testimony. Then we'll get to the verdict, and then we'll get to the appeal, which happened yesterday. So we wanted to cover the appeal hearing. That's why we're giving you guys this the backstory. All right, so this is from the day of March 19th, 2024. This is the video that is in question. I'm not sure what she's doing. Did she I guess she called her stepfather? Colleen, she's hiding all the stuff she was in trouble for? Yeah. Barry hiding evidence. Yeah, I guess she's hiding her evidence. I mean, she didn't say it was like a burglar gone bad or robbery gone bad or anything like that. She just straight up did it. She called her friend to come over, Holly. Yeah, we know that.
No further questions, Your Honor.
All right. Return the exhibit to the court reporter, please.
All right, so that's essentially. I think that probably is what did her in. But I was reading. This had to have some kind of role in it. Okay, so she had been prescribed antidepressant medications for anxiety and depression. She initially was prescribed Zoloft, but it was sertraline. Then she told her nurse practitioner the medications made her feel like a zombie. And then a week before this happened, she was switched to escitalopram, brand name Lexapro. So she was on Zoloft, and then she was switched to Lexapro. So, I don't know if you can just switch like that, or if, I don't know. I don't know if that had anything to do with what was going on with her. She was instructed to gradually wean off the first medication. Prosecution expert testified she reportedly did not follow the tapering instructions and instead stopped the first medication abruptly. So I guess that was Zoloft. So apparently she stopped Zoloft immediately. So, hey Eva, how are you? Good to see you. So I don't know if that had anything to do with this. I've never taken either one of those, but to me those are fairly serious, and you just don't, like change like that. I don't know. I think that had something to do with this. Had some kind of role. All right. So next up, this is from the Trial Channel. So we are happy to give a shout out to our friends over at the Trial Channel. If you guys are not familiar with them, definitely go check them out. They offer just clean streams. So this is from the Trial Channel. So this is Heath Smylie's testimony from September 17th. September 17th.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Have a seat. Adjust yourself up to the mic. You understand that you're now under oath and your answers will be sworn answers under penalty of perjury?
Yes, sir.
All right. You may proceed.
If you would introduce yourself to the ladies and gentlemen.
My name's Heath Smylie.
And Heath, we've met before today, that's right?
Yes, ma'am.
If you would, though, these ladies and gentlemen don't know you, so if you would just kind of tell them a little bit about how old you are.
39 years old. I'm a physical therapy assistant, and I've been Carly's stepdad for, it was almost, 3.5 years.
Tell me, excuse me, Heath, prior to March 19, 2024, who were you married to?
Ashley Smylie.
And when did you and Ashley Smylie meet?
It was the spring of 2019.
And at some point, did you and Ashley Smylie end up marrying each other?
We did in June of 2020.
Where'd y'all get married?
We actually went up to Gatlinburg when things opened back up after COVID.
Y'all like to take trips, be outside?
We did.
How old was Ashley Smylie when she passed?
She was 40.
And where did Ashley work?
She was at Northwest Rankin High School.
Can you describe for the ladies and gentlemen kind of what Ashley looked like?
She was very small, about 5'1", 5'2", blonde hair, blue eyes, super nice, real smart.
May I approach the witness room? I'd ask you to look at that. Can you tell me what that is?
It's a picture that we took. I guess we were up in the Smokies somewhere. I'm not sure which one that one's from. Might have been last fall. I don't know.
And it's a photograph?
Mm-hmm.
And who's in that picture?
That's myself and my wife, Ashley.
Your Honor, we'd ask that be marked as the state next exhibit.
Any objection?
No objection, Your Honor.
Be admitted as 7 all purposes.
Heath, I know that it's tough. I can't imagine what you're going through. But can you tell us, is the picture of Ashley that is in front of you, is that similar to the way she looked the last time you saw her alive?
Yes, ma'am.
Tell me about, you told us that, a little bit about Ashley's personality. I don't think there'll be any dispute that she loved being a school teacher, right? Loved her kids at school.
Yes.
Tell me about how much did Ashley love Carly?
They loved each other so much. She just, everything she did, she planned out for Carly and around Carly.
Before you and Ashley met, was she previously married?
She had been, yes, ma'am.
And who was she married to?
Kevin Gregg.
And did Kevin and Ashley have any other children besides Carly?
She had a second child that passed several months or a year or so later from a genetic abnormality.
And her name was Natalie Gregg?
Yes.
And she had passed before you met Ashley, is that right?
Yes, years before.
What did you know about the relationship between Ashley and her ex-husband, Kevin Gregg?
Only some things that Ashley had told me here and there. Things didn't go well and they ended up getting divorced.
And the ladies and gentlemen of the jury have seen some body cam footage of the day that your wife was murdered and you were shot. And on that, you mentioned that y'all were having some trouble with Kevin Gregg. Can you explain to us what was going on around that time?
I think he just liked trying to give Ashley trouble as much as he could through the legal system, any chance he could. I don't know exactly what all was going on, but she had acquired someone to try to get him back into court about possibly changing up visitation stuff again.
Had Carly ever told you anything about Kevin Gregg using drugs?
Yes.
So he was a known drug user?
Yes, ma'am.
I want to talk to you, Heath, about, you told us about how much Ashley loved Carly and that Carly was basically her life. Tell us about yours and Carly's relationship before March 19, 2024.
We were always good. We laughed and played and messed around, loved video games, and took her to karate stuff until she kind of got tired of that, and she started going to guitar practice weekly, so I was taking her to that every week. We got along great.
You liked being a stepdad?
Yes.
Sometimes with children comes discipline, right?
Yes, ma'am.
Would you say, or how would you describe the type of parent that Ashley was to Carly?
She was, like I said, always thinking about Carly and just Carly's first no matter what. She would do anything in the world for her and would try to get the best for her every day.
Were there times that you and Ashley would have to punish Carly?
Of course.
Give us some examples of that, Heath.
She had troubles growing up with back and forth with the stepdad and everything, so she would always wanting to try to make friends at the house and around home. And Ashley was always trying to, keep an eye on her, make sure she was okay and knew where she was. And Ashley had to fuss at her a time or two about, I know you can't go here, you can't go there, it's too late, that kind of thing. But she never really, day to day, got in trouble, really.
I want to ask you, was there a time that a boy named Thad came over to y'all's house?
Yes, ma'am.
Can you tell the ladies and gentlemen what you recall about that day?
We were all sitting at the house and there was a knock at the door, and Ashley checked the doorbell camera and we didn't know who it was. Carly had talked to us about Dad and we knew who it was, we just didn't have a face to the name. And Carly saw who it was and didn't want to see him, so I went to the door and just said, I'm sorry, I told him he must have the wrong house, and came back in and shut the door.
Where were Ashley and Carly when you were at the front door with Thad?
They went around, I guess, into the hallway or maybe one of the bedrooms, I'm not sure.
At any point, did it appear that Ashley was physically holding Carly back from going to the front door?
No.
At any time after you told told Thad that Carly didn't live there, did Carly act like she was upset with you?
No.
Did she act like she was upset with Ashley?
No.
Do you think that she would have been mad enough to have said, like, she almost murdered y'all because you wouldn't let Thad come in the house?
That's not the feeling I got from it at all.
I want to talk to you about back in 2021. Carly would have been in middle school, is that right?
Yes, ma'am. Yeah.
Were they living in the house with you?
Yes,
Carly and
ma'am.
Ashley? Carly was in the 7th grade, I think, then?
Sounds right, yes.
Was there an incident where Carly got in trouble for bringing a knife to school?
Yes, ma'am.
Tell us about what you know about that.
All I know is we had ordered some stuff off Amazon, and since she loved doing all the arts and crafts and stuff in her room all the time, making stuff, I showed her a Swiss Army knife I had found on Amazon like I had when I was young, and she decided on a color of one she wanted, and I ordered it for her, and she used it all the time in her room. And then all of a sudden one day I found out she had it at school in her pocket and somehow got in trouble with it. And I don't know what happened, but they said they couldn't tell us much more at the school about it. And that's about all I know on it.
Yeah. So the knife was in Carly's pocket, not in her book bag. Is that right?
I was understanding it was in her pocket from that morning when she was using it, but...
And then you didn't actually go to the school for any type of hearing in regards to that, right?
No.
That would have been something that Ashley handled?
If she went up there for that, I don't remember it. No, she might have, I don't know.
What did Carly tell you, or how many days did Carly tell y'all that she had actually brought the knife to school?
I thought it was just that day.
What was the result of her bringing the knife to school?
They have a zero tolerance policy on that and sent her to an alternative school until I think it was that Christmas break and let her come back.
So she had to spend time at the alternative school as a discipline.
Yes.
What, if anything, Heath, do you know about another time that Carly got in trouble at school for cheating?
That was, I can't remember if it was this past spring semester or when it was. Everything is kind of run together on exactly when. But at some point, she has always complained to us that kids constantly bug her for help with schoolwork because she can do all of it so easily and she can explain it to them better than most teachers. And she got so tired of them coming to her for stuff. Somebody just dared her or something, I'm not sure what. And apparently the teacher had a book or a computer or something open, and she took a picture with her phone of whatever was open up there.
Was it like the answers to a test or something like that? Something
like that. I'm not sure exactly what now, but yes.
And then she shared those answers with other kids? I
assume so, yes ma'am.
Was this is at the same school that Ashley taught at?
Yes.
How, from pure observations, how did Ashley respond when that happened?
She was just upset that she had done that, and she, talked to her about, can't be cheating, can't be letting others talk you into things. Just going with the flow of kids is not a good idea usually. So.
Heath, were there other, we talked about Thad, was there another boy that Carly was in some sort of dating relationship with that y'all knew about?
She had been dating Anthony. Honestly, forgot his last name right now.
That's okay, but you and Ashley knew about him?
Yes, ma'am.
Had he been to y'all's house before?
Yes, ma'am.
Was there any time that you or Ashley told Carly, hey, you need to end this relationship with him?
I didn't get into a lot of that. Ashley had talked with Carly about him and, some of the things that was going on, and they had supposedly ended it.
I believe you told, do you recall telling law enforcement that there were times that you and Ashley both would go through Carly's phone?
Yes, we tried to keep an eye on her.
Was there ever a time that you or Ashley took Carly's phone away from her?
So, Ashley had the parental controls on her phone, and we got to where we weren't going to let her take it into her room when it was bedtime. We had to keep it like on the kitchen counter, or we'd keep it in our bedroom sometimes. But she had her phone most of the time so she could be able to call or text us if needed. She might have not let her take it to school some days. I can't remember exactly, but most of the time when she was out and about, she had the phone, even if Ashley locked down some parental controls for a little while.
Why was it that y'all didn't want Carly to have the phone in her room at night?
She was worried that she would stay on it and messing with it and not sleep.
Was there ever a time after y'all thought that Carly had broken up with her boyfriend that y'all learned that in fact she had not broken up with him?
So Ashley worked at the school, and she told me she had still seen them, in the hall together, walking up and down the hall and things. And she talked to me about it and was like, she was okay with it and everything, as long as, it was okay and nothing harmful was coming of it for Carly.
Heath, do you recall a time that you and Ashley discovered that Carly had an iPod that she was using to communicate with people?
Yes, that was another thing that her dad had talked her into doing to get around communication. He was, I think, kind of paranoid about everything, and that Ashley might have been controlling Carly's communication with him, even though she always left those communication channels open, even when she locked down the phone.
Did it appear to y'all that she was in fact talking to her dad on the iPod?
I don't think so.
Who was she communicating with?
I'm not sure if she was communicating with kids so much as she was on like TikTok and some of that kind of stuff.
And y'all had asked her not to be on those accounts?
Yes.
Do you remember when that was, Heath? Around what time of year?
I don't remember that.
Was there ever a time that you and Ashley learned that Carly had been cutting her thighs with a knife?
Yes, and I was trying to think of a time frame on that, but it was, I don't know when, several months back, maybe a year.
And Heath, do you know anything about Carly taking any sleeping pills?
Nothing other than she used to sleep like a rock, and Ashley always had sleeping trouble, and she would take a melatonin at night, and it was a week or so she had a bad cold, and she was taking some NyQuil. I think she said that helped out some too. So
around the time that y'all found the iPod and Carly was cutting her thighs, is that about the same time that Ashley took her for therapy for anxiety and stress?
Within, I don't know, I think that was maybe a couple months maybe before, seems like.
Is that your understanding, though? That's what you told law enforcement of why Carly was in therapy, was anxiety and stress?
Yes, ma'am. It was something like that. I think she was kind of depressed some days.
And I think you told them that there were times that you would go maybe to the therapist's office with her, but you weren't actually sitting in any of those appointments, were you?
No, ma'am. I went up there with them a couple of times, but it was kind of a little waiting room outside.
And you don't have any personal knowledge about any medication that was prescribed, do you?
Not until after this. I knew she'd been on one and they changed her up to something else.
You don't have any knowledge on whether or not Carly was actually taking that medicine, do you?
She had been taking one a day, I think, until they wanted to swap her up to a different one. So I'm not sure on the time frames on that. I'm sure it's in the record somewhere.
Yeah, and Heath, so I've been prescribed medicine before, and sometimes I take it, sometimes I don't. Did you actually physically see Carly taking her medication?
Ashley would have her go get it and make sure she was taking the whatever it was, one a day or whatever. She kept an eye on that.
Do you know if on March the 19th, 2024, did you see Carly take any medicine?
The 19th?
Yeah, March the 19th of 2024.
No, ma'am. Not that afternoon.
The morning?
Oh, no. I don't know about that morning. She usually would take it in the evening when she ate.
Okay.
I think.
Sorry, that was a bad question. So Carly would actually take her medicine in the afternoon?
I think so.
Okay. When's the last time that you saw your wife alive, Heath?
That was the morning of the 19th.
Can you tell the ladies and gentlemen kind of how that morning went?
Everything seemed just as normal as ever. She got up and went to work just like always. She would fix tea or something in the morning and get in the car and take off. Nothing seemed unusual at all.
Did you also see Carly that morning?
Yes.
Can you describe for us what, if anything, you noticed about Carly that morning?
Didn't notice anything different.
How would Ashley get to work every morning?
She'd drive her and Carly down to the school.
And then how would they both ride back together from school to the house?
Yes.
Did they usually leave, or on March the 19th, did they leave before you or after you that morning?
Usually a couple minutes before.
What about, not on the 19th, but on a regular day, would they get home before or after you got home from work?
They were always home before me unless something happened at my work and I was able to get out a minute early, which is very rare.
What time would they usually get home from school?
I'm not sure on that. I don't know, I guess school was out maybe 3:15, I don't know. And it's whatever traffic allows, 15 minutes or something up the road maybe.
Typically, what time do you get home from work?
It varies. Usually I get out of work about 4:30, and sometimes I hit that evening traffic and it's 20 minutes or so before I make it 3 or 4 miles to the house.
And where is your house?
Right off of Old Fannin out in Farmington Station.
That's here in Rankin County?
Yes, ma'am, out towards the reservoir.
And the distance from where you work to where you live is probably only about 5 miles, right?
Yeah, it's not far. It's just morning and evening traffic takes a little while.
Do you know if Ashley and Carly were at school all day on March the 19th?
As far as I know.
I want to ask you, Heath, were there times that you and Ashley would text each other on your cell phone?
Yes.
Do you recall talking to Ashley on March the 19th?
I don't recall, other than that evening I got a text saying she was going to go to the grocery store.
Permission to approach the intern. Keep that handed back to you. If you don't mind, if you'll look through those messages, please. Do those, and admittedly, these are not all of the messages between you and Ashley Smylie forever, are they?
Right.
Does this appear to be a true and accurate copy of the messages starting at 4:30 that day when she's talking to you about going to Kroger?
It seems to be.
And are we to ask that these messages be marked as the state's next exhibit?
Any objection?
No objection, Your Honor.
Be admitted essay.
It starts at, I think it says 3:20.
And thank you, Heath. You corrected me.
Back with
Yeah, I apologize, Heath. You're right. The first message I was looking at was actually from the day before. I'm sorry, on 3/18. So on the bottom of that page, your page 2 of that exhibit, what does Ashley say to you? She says, I need to go to Kroger, thinking about going on the way home. Do you want anything?
Yes.
Did that appear to be a normal message that you and Ashley would have with each other?
Yes.
I think then you go on to tell her a couple things that you want. If you'll read for the ladies and gentlemen, kind of just a grocery list, right?
Yeah, just Mountain Dew, some soft serve ice cream, a couple of kinds of bread that I eat, and some random chips, just some junk food stuff.
And again, typical message between you and Ashley.
Yes.
And then at some point, does she respond back to you?
Yes, she replied back later, says gonna go later.
Still sounds like something Ashley would text to you?
Yes.
Tell us about what that next message is that you got from Ashley's phone, Heath.
Said, you almost home, honey.
Does that sound like something Ashley would typically say to you?
Not typically, but it wouldn't have been totally out of the realm. I think she would have phrased it slightly different, but I don't know.
What time was that text message sent to you?
That says 4:14.
Do you recall telling law enforcement that you thought that Carly actually sent you that text instead of Ashley?
I was wondering about that one at the time. Yes.
And then what did you respond to that message?
Said, no, I'll be here for a little bit yet, meaning at work.
And then you can't see it on this, but I think maybe Carly or whoever had her Ashley's phone sent you a thumbs up.
Sounds correct. Yes, it's not on there.
So, Heath, let me ask you, what made you think that that was Carly that sent that message and not Ashley?
I don't know, just something with the phrasing of it maybe. I'm not sure.
I want to walk you through, prior to March the 19th, 2024, did y'all have any type of surveillance cameras at your house?
Yes, we had a couple of things around. The Ring doorbell, well, I'm sorry, it's not a Ring, it was a Wise brand doorbell. Ashley had gotten to see if packages and stuff were being delivered during the day.
Were there other cameras either in the garage or inside the home?
Yes. 1 second.
Take your time.
We had one camera in the kitchen that I had actually gotten years before. I was going to actually put it at my mom's house so she could see what her dog was doing when she went outside. But the internet out there in the country is so slow it wouldn't run. So I had set it up at my house, I guess, well before I had even met Ashley. And it had just been sitting around, you know.
And that was a Wise brand camera also?
Yes, ma'am.
Do you know if that camera had any kind of like a SD card in it?
Ashley had put an SD card in it at some point, yes.
And I'm not super techie, but an SD card is just kind of something like you put in a regular camera to hold pictures or hold videos, is that right?
Yes.
Was there any way to tell what time a video popped up from that camera?
That camera was older and had some issues working with the newer software. I'm not sure on that. Ashley had been trying to work with it some, but...
Could you, I know I have a security system at my house, and there are times that mine's motion activated and that it'll ding on my phone and I can watch kind of who's outside my house. Did you have that ability?
No.
What about on the inside camera?
Well, the doorbell camera would ding if somebody walked up, like UPS dropping a package off or something, but the inside camera, she never could make it do anything like that. If it had that capability, it wasn't on or working.
So you weren't able to actually watch the inside from an app or anything like that?
I think you could pull up like a live stream on it, but it wasn't like dinging your phone every time the dogs moved in the house or anything like that.
Which is probably a good thing, right?
Right.
So I want to ask Keith, have you ever viewed the footage from the inside cameras from March the 19th of 2024 at your house?
No.
You said that there was also a camera in the garage area?
Yes. Ashley had set that one up maybe a week or something before.
Could you tell the ladies and gentlemen kind of how that camera was activated?
So she actually got that not to use as a camera. She wanted to be able to remotely open and close the garage door and make sure she had remembered to put it down when she left and that kind of thing. And Wise had a camera that she set in your garage that would watch the door. and it knew, to open or close it when you wanted to, and you had a camera as well. So she mounted it on the garage door opener itself.
And that camera, did it also record video and audio?
Yes.
The way that those clips work, how long is each clip on one of those videos?
I would have to go back and look at the time on that. I'm not certain.
Do you have any reason to disagree with the fact that it's like a minute clip at a time?
Perhaps.
Is there any way, other than deleting videos on those computer systems, are you aware of any way that somebody could go in and physically edit a video from that?
Not that I know of.
And Heath, at some point, and I want to talk a little bit about it later, but at some point, did you actually watch some video from the garage camera from March the 19th?
Yes, the Rankin County officers had been all out in the garage looking through stuff, and I just assumed that they had gotten the other in the cord and everything, and a couple days after, I guess it was the 21st, somewhere in there, I realized that the cord was still in, the SD card was still in the camera in the garage, and I was kind of looking at some of the footage that it might have caught.
Can you tell me, I believe there were 4 videos that may be relevant to March of 19?
That sounds right, yes ma'am.
2 videos of Ashley and Carly coming home, is that right?
I think so.
And then the video camera captures you pulling into the driveway and walking into the home?
Yes.
And then you've seen the last video, and you can't see the shooting, but you can actually hear when you walk into the house, yes, the first gunshot.
Yes, the newer cameras had the ability to start recording when they heard a noise, or I think I've even read where some of them are smart enough to hear the sound of if somebody breaks through a window or something like that, they'll start recording for home security reasons.
So you've actually listened back and watched that particular video?
Yes, ma'am.
I want to talk to you about, tell the ladies and gentlemen, Heath, and I know it's probably difficult, you can take as much time as you need. Tell the ladies and gentlemen exactly what you remember about when you came home on March the 19th, 2024.
Everything seemed pretty normal, and came on in, and when I opened the door to the kitchen there, gun went off in my face before the door was, 3 or 4 inches wide open, and everything kind of went pretty fast from there. It was a blur. So.
I want to take you back just a step. Yesterday, ladies and gentlemen, saw a bit of a video from inside your house, but just so we're clear, when you say you were coming into the kitchen, I believe you pull into the garage and there's a door that leads from the garage into the home.
Yes.
And then there's a little laundry room area.
Yes.
And then there's another door kind of beside your refrigerator that leads from the laundry room into the kitchen area.
Yes.
Were you coming in the first door or the second door when the gun went off?
The second door from the laundry room to the kitchen.
And do you remember, is there anything you do every day when you come in the house?
Usually stop and take my shoes off there and come on in and change clothes.
Do you remember if you took your shoes off on March the 19th?
I think I did, yeah.
Was it unusual for that second door to be closed in your house?
Sometimes it was, sometimes it wasn't. We would shut that door a lot of times, trying to keep the sound of the washer and dryer down, or trying to keep one of the dogs out of the garbage can that we had in there.
I have to do something similar. Y'all have 2 large dogs, right?
2 golden retrievers.
And so on that day, the second door was what was closed.
Yes.
I believe you said that you didn't get it open probably 3 or 5 inches before it went off. What did you remember seeing, Heath?
Just gun flash in my face, and then it went off 2 more times, but my hand was on the gun after the first shot, and I twisted it from her.
Who was pointing that gun at you?
It was Carly.
Who pulled the trigger when you opened the door?
The first one I know was Carly. After that, my hand was on the gun too, and I know I had a scratch on my thumb and all. I very well could have hit it. I know that third time.
How close, Heath, was that gun to your face when that went off?
Maybe a foot.
Did you ever get struck by a bullet?
Yes, one of them kind of grazed right through this muscle up here.
Can you tell, ladies and gentlemen, what did that feel like?
I know this sounds weird, but I honestly have never felt it to this day.
When the gun went off in your face, tell ladies and gentlemen, I mean, was your body in a state of shock?
Not at that moment. I was trying to figure out what was going on.
Did you see anybody inside your home other than Carly?
No.
Walk us through, you said that you were able to at some point get the gun from her. Tell us, Heath, what is it that you remember after that?
She was screaming out of her mind, scared. It was like she had seen a demon or something. She was terrified. And my first thought was there was an intruder somewhere, and she thought she was after somebody else.
And to be clear, Carly never told you that she thought somebody else was in the house, right?
No, that's the feeling that I got. She was terrified out of her mind.
And at that time, you did not yet know that your wife was dead, right?
No, not at that time.
So Carly's scared. She's screaming when she shoots at you. How many shots went off from that gun?
At that time, there was 3.
What type of gun was it that you took from Carly?
It was my Taurus revolver.
And what type of what caliber of weapon is that?
So the gun is a .357 Magnum, but I think it had 38 special rounds in it. If the gun's a .357, it can also shoot 38s. A little bit lighter recoil.
And what color was that gun?
It's just the gun matte silver.
Prior to taking it out of Carly's hand, where was the last time you saw that gun?
Ashley kept it on her side of the bed. So it had been there for probably a couple of years.
When you say on her side of the bed, was it on a nightstand or was it somewhere else?
I think she kept it. We had little cubbies underneath the edge of the bed. The mattress is sitting up on. I think it was sitting up under there.
Between the mattress and the cubbies, underneath
I think she just had it in a cubby under there.
Was the gun just loose, or was it in some sort of holster the last time you saw it?
I do not recall that. It was a while back. It had been sitting for a long time.
Did you have other guns in the house on that day?
Yes, I had an old shotgun that I've had for years that's unloaded in the closet, and I had an AR that I had gotten. It was also unloaded in the closet.
Were there some other guns maybe in a safe too, somewhere?
There was a Glock in the safe. There was a BB gun probably in the house somewhere too, I don't know.
Do you know if Carly knew the location of any of those guns?
She probably knew about the two in the closet, but like I said, they were unloaded, and the last time I had tried to talk her into shooting, she was too little to even hold them up. They're heavy, big.
And you had several guns in your house. Did you and Ashley ever go shoot guns?
Yes, we did.
That was something y'all enjoyed doing together?
Yes.
When you took the gun out of Carly's hand, what did you do with the gun?
I was holding on to it, and like I said, I at that time thought there might be someone else in the house, like an intruder or something, so I immediately started checking the house and looking for Ashley.
Did you attempt to call Ashley also?
I did.
I want to take just a step back, Heath. You get the gun from Carly. You said that she was screaming. What did she do next?
She fell back into the kitchen island, just kind of straight back onto her butt, and was screaming, jumped up, ran out the back door, and I mean, I'm still pretty quick and agile, but I knew I couldn't catch her. She was moving so fast. She ran out the back and took off, and I knew I wasn't going to be able to catch her, so I turned around, stepped back in, and I locked the back door behind me.
Do you know why you locked the back door?
Because I was thinking there might be someone else out and about and around, in or out of the house, so I went to checking the house.
Do you remember telling anybody that you were in such shock that you didn't even try to shoot Carly back or anything like that?
No, it was very evident to me immediately that something was very, very off with Carly. The way she was screaming, the way she looked, she was moving so fast.
So, Heath, you said Carly is at this point, she's out of the house, she's run off. You never actually saw someone, other than Carly at the house, right?
No.
So you locked the back door, you're going through the house, you have this firearm still in your hand. At any point, did you open up the firearm?
I opened the cylinder on it to check to see how many had been used or was left in it, and closed it back up and started checking the house.
When you opened it back up, how many live rounds did it appear were left in the gun?
Just one.
And how many rounds does that .357 Magnum revolver hold?
It's a 7-shot.
So you knew that she'd fired, at that point you knew she'd fired 3 at or in your direction.
Yes.
You did not know what the other 3 had been used for?
Correct.
The last time you saw that gun, were all 7 rounds live?
As far as I know, I guess the last time it had been used was a couple years before, or sometime when Ashley had shot at some, and I assume she had reloaded it.
So Heath, you're walking through the house. You have this gun, afraid that maybe there's somebody else in the house. You said, I believe that you tried to call Ashley.
Yes.
Did she answer?
No.
Did you find her phone?
Found her phone. It was on the counter in our living room.
Was there a second phone beside it?
Yes.
Did you recognize the other phone?
I didn't really stop to look.
So you realize that Ashley's phone is there. Walk us through what happened next, Heath.
Checked our bedroom, bathroom, closet, other side of the bed, under the desk in there, and turned and started going towards the other end of the house, and I glanced in our spare little 3rd bedroom, and then turned and went into Carly's room, and that's where I found Ashley.
When you found Ashley, can you tell the ladies and gentlemen what you saw?
She was laying on her back and had her hands kind of across her, and a towel over her face.
Do you remember what color the towel was?
I do not.
When you saw her laying there, what's the very next thing that you did?
Checked her pulse, see, and kind of moved the towel, and then called 911.
And Heath, when you moved the towel, what did you see?
I knew she had been shot. There was blood around, but I don't really recall exactly where. Somewhere in the right side of her face there.
You said you called 911.
Yes.
What did you tell the 911 operator had happened?
I tried to immediately tell him I needed the police out, that my wife had been killed and I had been shot.
Do you remember telling them who had shot you?
I assume I said Carly on there, but I don't remember exact details.
Do you recall telling the 911 operator that, oh my God, she's killed her mother too?
I don't recall saying that, but it's very possible, I guess.
At that point, Heath, did you think that Carly was the one that had killed her mother?
I didn't know what was going on at that point. I kind of went into shock there.
At some point, and again, the ladies and gentlemen, Heath, have seen some of the body cam footage from that day, but at some point, someone from the sheriff's department does come to your house.
Yes.
Walk us through what you remember happening once he gets there.
I don't know much there other than I got out the front door and just laid down on the front porch.
And it's pretty safe to say that you were still in a state of shock.
Yes.
At some point, were you loaded up by the paramedics?
Yes.
And where did they take you?
Took me to Baptist Hospital ER.
And what was the reason for taking you to Baptist Hospital?
They wanted to get me checked out and make sure everything was okay. They knew it wasn't real bad or anything, so they just trying to be cautious.
But you had in fact suffered a gunshot wound.
Yes, they got me down to the ER and they put a piece of gauze, taped some gauze on it, and sent me back home.
And it went through your kind of right, like trap muscle
Yes.
area. How far? I mean, not to pick on you, you don't look like a very large man. He's pretty average size. I mean, would you agree with me that where your trap muscle is and your head are about 6 inches apart?
I guess, yes.
So that shot was pretty close to your head.
It was close, yes.
You were, the gunshot actually, thank goodness, went kind of through and through, right?
Yes.
So you didn't require any surgery to remove the projectiles.
No.
In fact, Heath, I think you were actually, excuse me, I think you were actually released to go home that evening.
Yes, like I said, they tacked a piece of gauze on me, and I don't remember them doing a whole lot else.
And the night was probably pretty hectic as far as telling people what happened and what was going on. At any point, did you ever tell anyone that it was someone other than Carly Gregg that had shot you or Ashley?
Not that I recall, no ma'am.
And to this day, you've not told anyone that you think that the person that shot you or shot Ashley was somebody other than Carly, have you?
No.
We talked a little bit about law enforcement being at the house that night. At some point, they kind of released the scene back over to you, right?
Yes, I think when I returned back from the ER, they had finished up and cleared out, and there was a guy had me sign a paper, and went on back in.
Kind of saying the things that they'd taken from the home that night.
Yes, ma'am.
Heath, I mean, you go back home and they've taken some things out, but of course there's still, I mean, clear evidence that a murder had happened there, right?
Yes.
At some point, do you notify law enforcement about the garage camera?
Yes, on, I think it was Friday morning, I was looking through that SD card to see if it had caught anything. And of course the cops were looking all around, everywhere in the garage for various things, and had apparently not seen the camera. And they found the 4 videos that you referenced, and I called and told them I had found something else and they'd come pick it up or whatever, and they had still at that time not returned my driver's license to me, so they decided to bring that out.
And at some point they did actually get those videos from you?
Yes.
And to be clear, there was some confusion about an Apple computer and copying
yes,
versus cutting.
I had moved those 4 videos over to my computer, and I was just going to let them have the card with everything on it. And when I moved them over, it pulled them off the card onto the computer rather than like a copy and paste and making a copy onto mine. So the officers came back in and were talking to me about tampering with evidence and possible charges of messing with evidence, even though I called them out there to come get the card.
And to be clear, I don't think they ever told you they were going to charge you with tampering. They just explained that they didn't want it to look like somebody might have done that, correct?
No, he said we're trying to avoid having to charge you with tampering with evidence.
Okay. At that point, you're still pretty much in a state of shock, right?
Yes, there was 4 or 5 of them in my bedroom.
And in fact, if that was said to you, that would certainly not be indicative of what you would want to, how you would want to be treated, right?
I didn't know. I was just trying to be helpful at that point and figure out what had happened or why.
And I believe even on that day and after that, you did still continue to assist law enforcement in the investigation, right?
Yes.
At some point, you decided that you no longer wanted to communicate with the state or law enforcement, right?
Yes. After a few things that had happened, I went and got a lawyer.
Let's see. You talked about you told us about the garage camera and the incident, and to be clear, this was just an honest mistake, and I think that was relayed even by the officer and you, that this was, instead of copying and pasting something, you accidentally cut and pasted something.
Yeah, I mean, that's a new laptop that was sitting there. I was got it rather than a Windows computer this time to try out, and when I realized that mistake, I said, you can take the whole computer, just whatever, you know, and I had it sitting there open, so he just moved it over, got on the computer and moved it over himself, one of them.
At that time, no one had been able to find the camera from the kitchen, is that right?
Correct.
Where all, if you would tell ladies and gentlemen, I mean, we knew the camera was missing. Where all did you look for that camera?
Everywhere I could possibly think of. I looked high and low through the whole house. I mean, I wasn't looking just for the physical camera. I mean, it's a little shorter than that water bottle probably. But I was looking through small stuff even for the SD cards. Like, they're the size of your thumb. Postage stamp size maybe. And I was looking in shoes and boots and clothes drawers and pockets of clothes, I looked through every tiny little shred of garbage before I let any garbage go out of the house. I don't know, I guess it was that Friday, garbage comes through. Everywhere I could look for, and I continued to look for it for a long time.
And law enforcement had been at your house and also had searched kind of high and low in the home looking for that too, right?
After I got them to actually, look for it the second time around, they didn't seem to be too interested in finding it at first.
Are you aware that they also went and searched outside, looking everywhere between your home and where Carly was found?
I know they looked in the backyard, and one of them was kind of looking over the fence just to see if anything had been thrown anywhere.
At some point, was that camera found?
Yes, I later found it. As a lot of y'all know, when something happens, everybody always brings tons of food over. And the refrigerator had gotten just packed full of stuff, and we were slowly trying to clean that stuff out and get rid of it over time. And I found the camera back. It was actually back behind some water bottles, about like that, in the back of the fridge.
Was that the same day, Heath, that law enforcement had been looking for the camera at the house?
Yes, that's the third time they came out to search the house and the yard and all around. They searched and didn't find anything.
Who was there when you, who found the camera?
I did.
Who was there when you found it, Heath?
My mom was there, and like I said, law enforcement had just left a few minutes before.
And based off your prior conversation with them, you wanted to make sure that they were in fact the ones that came and got it, that you didn't mess with it, right?
Correct.
And so what did you do to let them know that you'd found the camera?
I called back the number that I had for Mr. Zach Cotton, and I don't know, I guess that goes to a front desk, and they had to patch me through somehow, or he called me back or something, I don't remember. Okay.
And what's your understanding of who Zach Cotton is?
He had given me his card to contact him. I'm just assuming he was like the main investigator.
And I want to take you back a step, and we'll come back to the camera, Heath. I mean, you had actually come in to the sheriff's department and given an interview with Investigator Cotton, right?
Yes.
And that was before this had happened?
I believe so. Yes, ma'am.
And that's when you told him that Carly was in therapy for stress and anxiety?
Yes.
Do you know how long that camera had been in the refrigerator?
I don't know.
Did you put that camera in the refrigerator?
No.
Based off what you know, how do you think that camera got put in the refrigerator?
I'm assuming that...
Objections, speculation, Your Honor.
Yeah.
Sustained.
I'll rephrase the question. When's the last time you saw that camera plugged in at your house?
I guess previous day. I might not have noticed if it had been gone then, but I'm assuming it was there the previous day.
And when you got home on March the 19th, 2024, was that camera still attached in the kitchen?
No.
And who was the only person besides your deceased wife that had been in your home that afternoon?
Well...
That you knew of?
At that time, Carly, but we since found out there was another person in there.
And do you, as you sit here today, you have no knowledge that that person moved anything in your house, right?
I don't know if anybody knows.
Sure.
I don't know.
Had she been over to your house before, the other girl?
Carly had a couple friends over a time or two, and I do believe she had been there once before, yes.
Did she have any direct interaction with you when she was there?
No, I was laying on the couch when a bunch of them came through and said hey, and they were in Carly's room or messing around in the backyard some of the time.
When you left for work on March 19th, 2024, did you ever see that morning or the night before, had you seen any empty vape pen boxes?
No.
If they had been sitting, if they were found at the desk in your bedroom, would you have seen those before you left for work?
I would believe so.
Do you know anything about Carly using drugs, Heath?
I had no idea of it until the events of I guess until the second police search.
And what are you referencing when you talk about the second search?
When they came back, I guess it was Friday, so after the murder had taken place, and they came out with a couple of things out of Carly's room that we had no clue of. So I don't know anything about them. It was new to me.
When you told law enforcement that you'd found the camera in the refrigerator, at that point, did you give them consent to kind of see what was on that camera?
Yes. He had me sign something as he was taking it, so I assumed that was consent.
I want to take you back to the interview that you gave with Investigator Cotton, and you probably don't remember the contents of all that, right? It was,
not at this time. I think we were in there for a while and covered a lot.
do you remember talking to him about what might have been stressing Carly out at the time?
I don't remember that conversation, no.
Do you remember him asking you, kind of midway toward the end of the conversation about if there was anything else that you knew about Carly or about what was going on that might be helpful to their investigation?
I don't remember at this point what was said there. I know y'all probably got a record of it, but I don't recall.
And that's okay. When traumatic things happen, our bodies respond in certainly different ways, and I don't think anyone in this room wants to experience what you've experienced, and so I don't expect you to remember everything. You had a lot of questions on that day, right, about what happened?
Yeah.
Heath, at some point, there was a no contact order put in place between you and Carly.
Yes.
Did you ask the court to lift that?
Yes.
And since that time, you've had contact with her?
Yes.
At any time during your communication with Carly, has she told you that she was not the person that killed her mother?
No. We have not had any kind of conversation, anything like that. Nothing to do with the case or the trial.
Do you see Carly in the courtroom, Heath?
Yes.
If you could you point her out?
Right there.
And could you tell me where at that table that you pointed at that she's sitting?
She's in between Mr. Camp and Miss Todd in black.
And is that the same person that shot you with that .357 Magnum on March the 19th, 2024?
Yes.
May the record reflect the defendant's identified that the witness has identified the defendant.
Record reflect is identified the defendant.
I have no further questions at this time, Your Honor. Thank you, Heath.
Approach real quick.
Cross-examination by the defense.
Thank you, Your Honor. Mr. Smylie, we heard a lot of testimony on your direct with the prosecutor regarding the garage videos and what was on the garage videos, and you transferring the garage videos to a flash drive for the police. Did you have an opportunity and before you were transferring them over to view those garage videos?
Yes, the 4 from that afternoon I had seen, yes.
Okay. And we talked a lot about them on direct, but we're going to go ahead and play those for the jury so that everybody
Let's practice real quick. By agreement of the parties, this exhibit will be marked as S9 and admitted for all purposes.
Mr. Smylie, is that a true and accurate representation of what you recall once you got home that afternoon?
Yes.
Okay. Who was that screaming that we heard on the video?
It was Carly screaming, and you heard me holler, "What's the matter?"
And what about seeing Carly made you ask her what was wrong?
I could immediately tell that something was bad wrong with Carly. Just the screaming, her eyes were just huge. She looked like she was terrified.
Have you ever heard Carly scream like that before?
No.
Have you ever seen Carly look as terrified as she did on March 19th before?
No.
Would Carly have any reason to run from you?
No.
Mr. Smylie, can you describe the full floor plan at your house?
I guess it's what you call a split. And it's got kind of on the north end, it's a master bedroom, bath, and closet. Living room and kitchen kind of in the middle, and then on the other end there's two smaller bedrooms that share a bathroom in between the two.
And where was Carly's bedroom?
It was on the southeast end of the house.
And
Corner.
you mentioned that there was where Carly's bedroom was, there was also a bathroom and another room.
Yes.
What did you use that other bedroom for?
A lot of just general storage stuff, and had some weights, and there's a little treadmill in there.
Kind of what we call like a junk room.
Yeah, a lot of junk in the closet on a shelf and laying around. And
Okay. And is there a hallway that separates the kitchen and the living room from that side of the house?
yes.
Okay. And where was the indoor camera located?
It was in the corner of the kitchen/dining room open area.
Okay. And is the kitchen, living room area of your house, is that open?
Yes.
Okay. And let me ask you this. How would you describe your and Ashley's marriage?
We got along great. I don't guess we ever really had anything we just disagreed on or anything.
And were you still in your honeymoon phase?
Yeah.
And just for the record, you can't nod. You have to answer yes or no for the court reporter.
Yes, I'm sorry.
And what, if anything, had Carly told you about her biological dad, Kevin Gregg, doing drugs?
Everyone that I can think of, it sounds like he has either tried or does regularly.
And what did Carly tell you about her biological dad doing drugs in her presence?
He was constantly doing drugs in front of her, blowing smoke in her face. Turns out that he sat her down and made her drink an entire beer when she was 12.
And what, if anything, had Carly told you about her dad offering her drugs during her visitation periods?
Not sure on that, but I think she said they were laying around all over the place throughout his house, and I think he had tried to get her to do some various things at one point or another.
And would you say that Carly was scared of her dad?
Yes. She did not like having to go up there, and she was not herself for a day or two after coming back.
Okay. And would you say that Carly's mom was scared of her dad?
Yes. Anytime they spoke of him, it was like a deer in the headlights. They would freeze up and be shaken sometimes if they were talking about him.
And how would you describe Carly's relationship with her mom during the time that you came into her life in spring of 2019 to March 19th of 2024?
They got along great, loved doing things together. They liked a lot of the same movies, and they'd go shopping together, and they stayed together quite a bit.
Pretty tight bond.
Yes.
And is it fair to say that Ashley was protective of Carly because she'd lost a child already?
Yes, she wanted the best for Carly, watched over her all the time. Yes.
And is it fair to say because Ashley was protective of Carly that she was a little on the stricter side with things like social media?
She was, yeah. She, would read all the bad things that happened in the news and all that, and she didn't care for any of it. And I think TikTok's probably one of the ones that she didn't care for.
And TikTok was what Carly had put on the iPod, the old iPod?
Yes, just watching the usual stupid videos.
Yeah, and we've heard the phrase burner phone a few times, but when we're hearing burner phone, are we talking about the old iPod?
Yes.
Okay. So the burner phone is the old iPod she had that she somehow downloaded social media apps to?
Yes.
Okay. And Carly was in 10th grade at the time that you guys found the iPod?
Yes.
With the social media apps?
Mm-hmm. Yes.
Would you say that most 10th graders want to be on social media?
Calls for speculation.
Were there any other social media apps Carly had on the iPad?
I can't remember at this time. Ashley had taken care of all that. She was way more tech savvy with that stuff than I am.
Had you and Ashley already found the old iPod?
Yes, we had. She had found it and figured out what was going on. Yeah.
And when did you guys discover the old iPad that's called people have been calling the burner phone?
I'm just going to have to say sometime last fall. I don't know the exact time frame.
So not in March?
No.
And we talked about an incident with Carly looking on her teacher's computer at school. Did Carly need to cheat to get good grades?
No, she loved school, but she was almost bored with school a lot of days. It was, even though she was in the advanced classes, she's a light year ahead of everything they're teaching. Okay. Anything new she picks up and just wants to be a step ahead of the teachers.
And hadn't Carly told you about that incident that the kids in her class had dared her to?
Yes, they had. Yeah, she told us about it.
Okay. And how would you describe your relationship with Carly?
All good. We've gotten along from the beginning. Hadn't really had any problems between us.
And do you have any other children?
No.
And would you say that you love Carly the same as you would a biological child?
Yes.
Okay. And what, if anything, had Ashley told you about her ex-husband's mental health issues?
Objection, Your Honor. Hearsay.
What, if anything, had Carly told you?
Objection, Your Honor. Hearsay.
Sustained.
Have you ever had any interactions with Mr. Gregg?
No, other than I would see him in the car picking up or dropping Carly off. And a lot of times he would drop her off and leave, wouldn't even check to see if she was getting in the house.
Okay. And you said that the handgun that was used in this incident on March 19th was kept under Ashley's side of the bed?
Yes.
Was it kept in a lockbox or anything like that?
No, she just had it under the little cubbies and all we had built out for kind of storage. She had set it under there.
Okay. And why was she sleeping with a loaded handgun under her side of the bed?
She was terrified that the ex was going to show up one day and she wanted that there.
Okay. Now, in the time that you've known Carly, the 3.5 years from spring of 2019 to March 19th of 2024, had you ever seen Carly be violent?
No.
Had there ever been any incidents in which Carly was in trouble for being violent?
No, not that I know of.
Okay. Had you ever seen Carly enraged?
No.
Had you ever seen Carly get mad?
No, she'd get frustrated with something every now and then if she couldn't make something work like she wanted to, or something in a video game, but she would work at it over and over and over till she figured it out and got it.
Okay. Had Carly been having any trouble at school?
No.
Had she been having any trouble with friends?
Not that I know of.
Okay. And you mentioned that Carly had a boyfriend with at school, and at first Ashley didn't like it, but then she was okay.
Yes.
Why did Ashley first have a problem with Carly having this boyfriend at school?
Just in general, she had told her she didn't want her dating until she was 16 or so, at least, and just trying to watch over her.
Okay. And do you recall a statement that you made to law enforcement back on March 19th about y'all had been having problems with Carly?
Again, I don't remember exactly what all I told them at this point.
Okay. What, if any, issues had you and Ashley been having with Carly?
Just not really any problems with her, other than I think she was kind of at times depressed, or she's a teenage girl, maybe emotional, but she ended up, we got her to a clinic up close to her, I guess it's in Madison there, to let her talk with a therapist.
Okay. And what had led you and Ashley to decide to put Carly in counseling?
She just didn't seem like she was her normal happy peppy self. She was just kind of depressed and sitting around more, and she she said she thought talking to somebody might help her.
Had you noticed anything else that was going on with Carly that concerned you at that time?
Not that I recall. She was kind of having problems with time management kind of stuff, and maybe remembering a couple things, which was a little unusual for her with schoolwork stuff.
Can you tell me about the issues she was having with remembering things?
Just
Yes, ma'am.
Mr. Smylie, can you describe the depth of your injury that you sustained on March 19th?
It's just a spot went through my edge of the upper trap muscle right there, and kind of zipped right through. And like I said, oddly enough, I know it sounds weird, but I've never really felt it or had any trouble with it.
Did you require stitches?
No.
Okay. I think we heard an officer on one of the other cameras call it grazed. Is that a fair description?
I guess, yes.
And Mr. Smylie, do you have any idea why Carly would want to shoot you?
No.
And we all heard Carly screaming when you walked from the garage into the kitchen on March 19th. How did Carly appear to you when you walked in?
Like I said, my initial thoughts were she was terrified, scared out of her mind. I still to this day don't think she ever even recognized me. Something was wrong there. I don't know what, but something was off.
And when you walked into the house, did Carly say anything to you?
No, just was screaming.
Did she say anything in response to your question? What's wrong?
No.
Is that like the Carly that you had known for the past 3 years?
No, not at all.
Did Carly ever have any interest in guns?
No, Ashley had wanted her to go shooting with us a time or two, and I had tried to, get her to shoot a couple different times, and I think Ashley or somebody might have taken pictures the time or two that she went, but that was it, and she never was interested in going when myself and Ashley went.
And in all the time that you've known Carly, would you describe her as callous?
No.
Would you describe her as calculating?
No, except with math.
Would you describe her as diabolical?
No.
How would you describe Carly?
She's just a sweet little girl ever since I've known her. And, even when we take her to the playground, instead of running around playing, a lot of times she would be pushing other kids on the swing and the little, I don't know what they're called, little roundabout things that kids get on and go in a circle. She'd be the one that'd be pushing groups of kids rather than her playing. She'd go find the younger ones to try to help take care of them, and she's just sweet.
And are you aware of any medication Carly had been placed on?
And I can't remember the names of which one was which, she had been placed on one by the therapist that they had started her on something.
And do you recall what that medication was for?
Whatever they thought it was, whether it was, I don't know, just generalized stress or depression, or I don't know what they were thinking it was.
Okay. And do you recall how many medications that she'd been on?
I know she was on one, and then approximately the week before the 19th, they swapped her to another one.
Okay. And with the first medication that Carly was on, did you notice any changes in her personality or demeanor?
No.
And with the second medication that Carly was on, did you notice any changes in her personality or demeanor?
No. She had only had a chance to be on it for a handful of days. I don't know exactly how many days, but she was just getting started on it.
And do you and Carly still have a relationship?
Yes, I think we're good.
Okay. And how frequently do you and Carly talk?
Just about every day now. I don't always get off of work in time to catch her on a phone call, but we text some back and forth over the app that's allowed, and we talk over the video chat thing that's allowed through the jail and on weekends. So we're good.
Prior to March 19th, had you ever been afraid of Carly?
No.
Are you afraid of Carly today?
No.
Prior to March 19th, had Ashley ever been afraid of Carly?
Objection, Your Honor, cause for speculation.
Sustained.
Based on your observations and personal knowledge, had Ashley ever appeared to be afraid of Carly?
Objection, Your Honor, again, cause for speculation.
Your Honor, he can say what he observed.
Y'all argue in front of the jury. Y'all approach. All right, the objection is going to be overruled. You can answer the question based on your observation and personal knowledge. Did Ashley appear to be afraid of Carly?
No, not at all.
And you testified on direct that you had retained your own attorney after the investigation of this matter got started. And you said that that was because you had been concerned or felt worried that you were going to be charged with a crime?
Yes, the cops had insinuated the tampering with evidence. They held my license for several days, wouldn't bring it back. I kind of think it now that they were maybe trying to keep me
Objection.
around.
Calls for speculation.
I sustain. You can testify to what you observe, but you can't testify to what you think other people would do, okay?
Okay. And then I went and got a lawyer from there.
Okay. And why would you have tried to hide evidence that you were telling law enforcement about?
I have no idea. I was trying to find anything I could that might help out and figure out what or why.
Was law enforcement aware that there was a garage camera on March 19th?
I don't believe so. They were all around out there apparently looking at stuff. I don't know, 5 or 6 of them, and they never saw the camera or never bothered to mess with it, more than likely.
Had any members of law enforcement asked you about any cameras?
No, not that I recall.
Okay. And you spoke on direct examination about them turning the house back over to you. About how long did law enforcement have your house under investigation on March 19th?
I had been down to the ER and back a couple hours, 2.5 hours roughly maybe, because it had gotten dark by the time I got back there.
Okay. And how many times after March 19th did law enforcement issue search warrants to come back out?
2 more times.
Okay. And during those 2 other times, now making 3 times that law enforcement investigated your house, did anyone find the camera in the fridge?
No, they did not.
Okay. And they didn't ask about any cameras in the garage?
No.
Okay. Now, so you were very forthcoming with this evidence?
Yes.
Okay. And you also had your attorney file a motion to rescind the no contact order between you and Carly, correct?
Yes.
Had you asked that that be done beforehand?
Yes, I had tried to get my first attorney to get some of that in motion, and I don't know what happened there. It kind of fell through.
And has anyone else made you feel intimidated during the course of this investigation?
I was told by the DA's office that I couldn't contact anyone else, like y'all that were working with her about anything, couldn't speak with anyone else. And then
You were told you...
Objection, Your Honor. We're afraid.
Sure.
So, it's understandable that you would be a little guarded,
yes.
and that this has been a long, ongoing investigation, and it's hard to talk about this stuff emotionally.
Yes, at times, worse than others.
Yeah. And that you have been interviewed about this previously.
Yes.
So, you're having to go back over the same stuff repeatedly.
Yes.
And it's hard to testify. It's nerve-wracking.
It is.
And this is being televised and broadcast, and there's been a lot of scrutiny, so it's understandable that you would be guarded and nervous while testifying.
Correct.
Please interview.
Redirect examination.
Heath, how many phones did you know of that Carly had?
I just knew of the one that we had gotten for her.
And so if law enforcement had 2 phones they recovered belonging to Carly from the scene, that would in fact be more phones than you knew about, right?
Yes.
Do you think that if someone shoots at me unprovoked, that that's a violent offense?
I guess so. It really depends on the circumstances.
Again, unprovoked. I'm walking into this courtroom, and out of nowhere, this gentleman closest to the door, as soon as I open it, pulls out a gun and fires it at me. Is that a violent offense?
It could be. Depends on the circumstances.
You said that Carly, you never saw her get mad or yell?
I have never seen Carly just angry or anything.
Never.
No, ma'am. She's always been just a happy little girl.
Was she a happy little girl when we just heard the video when she was firing a gun at you?
Like I said, I've never seen anybody like that, even in movies. She was not herself, and like I said, I do not believe she even recognized me. She was terrified.
And Heath, I believe on direct, when I asked you about medications, you actually didn't handle Carly's prescriptions or medications, right?
No, Ashley was making sure she was taking them.
I want to talk to you, Mr. Smylie. You said that law enforcement came over a couple times and they didn't find these cameras. Did Miss Todd and Mr. Camp come over to your house at some point?
Yes, they did.
And when was that?
I think it was after the second police search.
And at any point, did they also conduct a search of your house?
They came through and wanted to take pictures and get the layout of the house.
Did they take anything from the house?
I think they took a couple pieces of her artwork and a couple things like that, but I'm not certain at this time.
And you don't know as to what they did with those, do you?
I do not.
Did they ever find the camera in the refrigerator?
No.
Court's indulgence. There are no further questions.
May this witness be finally excused by the state.
We'd ask that be subject to recall.
All right. Mr. Smylie, I'm going to ask you to stand down, but you're going to need to leave the courtroom and not discuss your testimony with anybody. You're not free to...
All right, so that concludes Heath Smylie's testimony, and big shout out to the trial channel for having that available and allowing us to watch. So thank you for that. All right, so now we're going to go to the verdict and then the sentencing, and then I'm going to have biological dad speak. I've got a minute. I kept trying to post in chat here, and it wasn't allowing me to post. So I wanted to say we have a video of his interview. Well, he talks on the news for like a minute. All right, so verdict and sentencing, then dad speaks, then we're going to go to the hearing, which was actually yesterday, but we're trying to give you guys some context, kind of refresher, if you will, instead of just showing the hearing. The appeal hearing, I wanted to show some context and kind of get back into it. Oh, this is from the trial channel too. Awesome. Also, I should say, this is from the trial channel as well. So after 2 hours of deliberation, the jury in the case of Mississippi versus Carly Gregg reaches a verdict. And also, Florida PI Sam is going to be doing a stream this Saturday about kids and their parents. So she's going to be talking about Carly Gregg. So we've been dropping, here, I'll drop it again, the link. So if you guys, 4:15 Saturday afternoon. So if you guys are interested in hearing Florida PI Sam's perspective, because she's part of the defense team that has these kids. These kids are committing these horrific crimes when they're 14, 15, 16 years old. So definitely check out. If you aren't doing anything Saturday at 4:15, definitely check that out. Hey, Ambi, how are you? Good to see you. Vox 4 is working overtime. Everybody's dropping kids. So anyway, yeah, check that out. Or join Sam. We'll be there. We will be there in chat. So definitely, if you guys are interested, come check that out.
Now in session, Honorable Billy Arthur presiding.
All right, please be seated. All right. the court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. These people did not ask for this job. They didn't want the job. The state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. And it is a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury. You can sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts.
Yes, sir.
All right, if you would, please hand the paper to the bailiff. Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count 1. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count 1, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes. Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry.
Yes.
On the back row, sir, is that your verdict? Unanimous. Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
All right. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce one photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct, Your Honor.
Show your piece of evidence to the other side. Any objection?
Yes, Your Honor.
Y'all approach. All right, the state has moved.
All right. So one of the things that the defense is claiming. So these are the arguments from the defense were claims that Carly's constitutional rights were violated during compelled psychiatric evaluations. All right, we didn't watch that. Alleged that the trial judge rushed the defense toward trial. Only watched a little bit. Allegations, objections to certain expert testimony, including references to crime and punishment. Didn't really hear that. Sentencing issues involving juvenile parole eligibility and life without parole standards. So now we're into the sentencing part. Prosecutorial comments during sentencing that the defense has improperly discussed parole fears with the jury. All right, so let's pay attention to that because sentencing is coming up. So this is one thing, sentencing issues involving juvenile parole eligibility and life without parole standards, and then prosecutorial comments during sentencing that the defense has improperly discussed parole fears with the jury. All right, so let's pay attention to that. Let's see if we can Super Bowl. Let's see if we can pick that out. Super Bowl, are you gonna pick it out? All right, so here's sentencing coming up. So pay attention. Let's see if we can hear the defense complaining about prosecution making comments discussing parole fears. So let's see what happens.
To adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
No, sir, Your Honor.
All right, defense may call any witnesses.
We don't have any witnesses, Your Honor.
All right. With the defense not calling any witnesses, attorney's approach. Does the defense rest its case in chief as to sentencing?
We do, Your Honor.
Do you also move to adopt and incorporate by reference the record?
We do, Your Honor.
All right. Y'all approach. All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1. The defendant's chronological age. 2. The defendant's family, home, and environment. 3. The circumstances of the homicide offense. 4. The defendant's incompetencies associated with youth. And 5. The defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows. Quote, as to count 1, we the jury are unable to affix the punishment. Close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count 2. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1. The defendant's chronological age. 2. The defendant's family and home environment. 3. The circumstances of the homicide offense. 4. The defendant's incompetencies associated with youth. And 5. The defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count 2, we the jury sentence the defendant, Carly Madison Gregg, to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows, quote, as to count 2, we the jury sentence the defendant, Carly Madison Gregg, to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows, quote, as to count 2, we the jury are unable to affix the punishment, close quotes. All right. First closing by the state as to sentencing. Mr. Bailiff, 7.5 minutes. You wish a 2-minute warning or a 1-minute warning?
1 minute is fine.
1 minute. You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life.
When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets, when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You had to watch that terrible video. We listened to Ashley Smylie's last sounds. We heard from Heath Smylie on that 911 call, the desperation. He said, "Help me. Help me." Ladies and gentlemen, those crimes were awful. She has shown zero remorse. Zero remorse for what she has done. Let's talk about her ability for rehabilitation. The defendant's own expert during the guilt phase of this trial said, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime and that she's continuing to have these disassociated spells. And obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole. If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters. Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smylie, and the attempted murder of her stepfather, Heath Smylie. Thank you.
15 minutes total.
Thank you, Your Honor.
Yes, sir.
I'm going to have to tell you, this is probably the most difficult thing I've ever had to do. I respect your jurors, and I respect your verdict, and I totally understand that. And now I'm in front of you. Carly Gregg, when this happened, was 14. She's 15 now. Her family's sitting on the front row. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. Heath Smylie, who's the victim in this case, he has been supportive. This is a family that's been torn apart because of this. This is extremely, extremely difficult on all of them. And I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. you have three options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you, let the judge make the determination. We don't want you to give her a sentence for life in prison. Life in prison is life in prison. That's it. 14-year-old. She can come out of this at some point. Anywhere you were hearing, she can walk out of here in 10. We don't, first of all, we don't know. Usually it's a lot longer than that. I mean, a lot longer. So, I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
Ladies and gentlemen, Mr. Camp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again? We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in voir dire about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County. And my office is asking you to please sentence Ms. Gregg to life in prison without the possibility of parole. Thank you.
Ladies and gentlemen of the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits. I've been told that the jury has reached a verdict as to sentencing. I don't know what the jury's verdict is. As I said before, they didn't ask for the job, and we will not praise their verdict, and we will not condemn their verdict. Any outburst, positive, negative, whatsoever, will be direct contempt of court, and you will serve 30 days in jail for each outburst. If you cannot control your emotions, you should leave the courtroom at this time. Mr. Bailiff, please bring in the jury. All right, the verdict appears to be in proper form. Ms. Gregg, if you and your attorneys would come to the podium. The verdicts read as follows. As to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. As to count 2, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Please be seated. Ladies and gentlemen, just as I did with the verdicts of guilt, not trying to be rude. It's the quickest way we can get it done. As to count 1, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Yes, sir. Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, sir, is that your verdict?
Yes, sir.
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
As to count 2, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment. On the front row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
Sir, is that your verdict? And sir, is that your verdict?
Yes, sir.
Verdict appears to be in proper form. Ladies and gentlemen, the jury, please exit. I will be there in just a moment to release you, okay? Everyone remain seated while the jury exits. Ms. Gregg, please come to the podium. Your sentences will be as follows. As to count 1, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count 2, you'll be sentenced to life imprisonment. As to count 3, you'll be sentenced to 10 years to serve. You'll be required to pay court cost fees and assessments in the amount of $431.50. Ms. Gregg, regarding any appeal of your judgment of conviction and order of sentence and in accordance with Wright v. State 577, Southern 2nd 387, the court wants to inform you that pursuant to Rule 4E of the Mississippi Rules of Appellate Procedure, the notice of appeal required by Rule 3 of such rules shall be filed with the circuit clerk within 30 days after the date of the denial of any motion for a new trial, or the date of imposition of sentence, whichever is later. Pursuant to Rule 4E, if you make a timely motion under the Mississippi Rules of Criminal Procedure for a judgment of acquittal notwithstanding the verdict of the jury or for a new trial under Rule 25.1, the time for appeal shall run from the entry of the order denying such motion. Finally, Rule 25.1 subsection C provides that a motion for a new trial must be made within 10 days of entry of the judgment, which includes both adjudication of guilt and sentence. Should you make a decision on the record to appeal, that decision will stand unless a written statement to the contrary signed by you and your attorney is filed with the court. Should you make a decision to waive appeal, that decision will stand unless you give written notice to the court and your attorney prior to expiration of the time in which to perfect an appeal. Should no decision to appeal be made by you, your failure to express a desire to appeal shall be considered a waiver of your right to appeal, and that waiver will stand unless you give written notice to the court and to your attorney prior to expiration of the time in which to perfect an appeal. Have you made a decision to appeal your conviction and sentence?
Well, we'll do it.
All right. Court will be in recess.
Your Honor, thank you for clarification. I apologize on those.
Sentences will run concurrent.
All right, so I guess the remarks, the prosecutorial comments during sentencing. So it was about, if she gets out, if she doesn't get life without parole, we have no idea when she's going to get out. She's a sweet little Carly, but unfortunately we all know that's not the case. Nothing would stop her from walking into a shopping mall, going into school, going to the grocery store. I guess that's what the defense is arguing, that kind of went over. They went over. I don't know. That's not for us to decide. That is for the appellate court to decide. All right. So now I want to play Kevin Gregg. Kevin Gregg's. He speaks, and then we'll get to the hearing right after this. Let's see, where did I put him? Here he is. Okay.
I love Carly, and I would love to have tried to help her the best I could. I kept screaming in my head, why couldn't you just have called me? Ashamed, embarrassed, angry, upset, very sad. I loved her too. We were married for almost a decade. We had really enjoyed ourselves, and she was a wonderful child, and she was obviously multi-talented, gifted. We loved each other. We loved that girl. She was right before she turned 4 was when she separated from me and Ashley. She had suicidal ideation on record in Warren County. That girl knew right from wrong. That girl is not insane. That was a very dumb defense, if you ask me. But I wasn't involved. Nobody ever called me. Previously in my life, I did a lot of drugs. Yes, and I admit them. I don't think anything's going to help Carly unless she wants to use the truth and rehabilitation and remorse, as defense tactics. I don't want to judge her. I hope she finds Jesus. I hope she can reconcile with what she did.
All right, so that was Kevin Gregg talking. Now let's get to the hearing. Now that we have our context, hopefully everybody is up to speed on what happened. So now let's get to the actual arguments here. These are oral arguments from yesterday. Let me go over here. And this is brought to you by Top Mark Media. So I know you guys know Top Mark Media and RA, Recovery Addict, Scott. So thank you to Scott for letting us use this video. Let me just cue it up here. All right. All right, here we go.
All persons having business before the court shall draw near and give their attention for the court is now in session. God save the United States, Mississippi, and its honorable court.
Be seated. Mr. Clerk, would you sound the docket, please?
2024 KA 1178 SCT Carly Madison Gregg versus the state of Mississippi.
What says the appellant?
Appellant's ready, Your Honor.
What says the state?
The state's ready to proceed, Your Honor.
Okay. Mr. Murphy, we'll hear from you.
Thank you, Your Honor. Good morning. Justices, may it please the court. My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the state of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the state of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute, on subsection 2 of the sentencing statute for first-degree murder, gives two options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here, and I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences, life without, in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years, and this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument. But the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument. But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does the judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments, but assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smylie. She was listed as a potential witness, and she was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year, and again, I'm paraphrasing, but you may see her at the supermarket or you may see her at church. You may run into her at any place outside in public, and again, we would argue, and we argued in our brief, that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue and has argued in their brief that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief. We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they began their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase it too. If Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smylie or the trauma suffered by Heath Smylie. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
yes,
let me just interrupt you there for a second. I want to clarify something for purposes of I know this court has written it for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder. We have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated, and in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court in that case vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, we recognize that there are cases even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed. So we would submit to Your Honors that this court has the power to impose that duty on the trial court just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice, that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now that posture shaped the atmosphere of the litigation from the very beginning. Now you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances, and that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Mr. Murphy, without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Well, Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing in those cases and the text of that rule still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion, written motion before trial or during trial, and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because it number one, it chilled the litigants. They I hate to say afraid perhaps, but and going back to Smith versus State,
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers, and certainly there's no reason a motion couldn't have been made. But I'm just wondering, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluation, which we think were premature and beyond the scopes of the Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket. Announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me as a defense attorney to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Minalton standard. So they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power. The court does not have the power to order Carly to undergo psychiatric evaluations at the behest of the state. The court.
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right, does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
the
evaluation?
Only reason she declined to render an opinion was because there were some issues with marijuana or some other.
Whatever the reasons were.
Right.
Does that affect your argument that it was incorrect for the trial judge to order?
It absolutely does not affect my argument. That was premature and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents that wouldn't have otherwise yet disclosed?
Among other things, yes, Your Honor.
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think that we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you.
Okay. Ms. Hartman, the court will hear from you at this time. Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to. And the sentencing statute in this case allows for 2 sentences: life in prison if that's set by the jury, and a term of years. All right, so the sentencing the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I get why you say the effect of her sentence is life without the possibility of parole, and I think that's relevant to the Miller discussion. But as to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
Yes, Your Honor, it
does. And you will agree with me that that is one of the legal sentences under the sentencing statute?
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason that they would, but if they did, and they were to remove the language that says you're no longer eligible for the language that says you're not eligible for parole if you're convicted of first-degree murder. That's what relegates this effectively to a life sentence we've held. Then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those 2 statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute, and you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have...
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole. In Parker, we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. Mm-hmm. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, I mean, it just didn't follow the sentencing statute, because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, what? A life sentence with the possibility of parole, but that's not what the statute provides. And the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means, under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute, because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
Okay, and I might disagree with that, because again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past has reformed the parole procedures and the parole, what if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? Do we have to go back and re-sentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think Johnson, this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was re-sentenced.
The sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was re-sentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Well, do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Okay. Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language life imprisonment under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life imprisoned sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the sentencer, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times, point blank range in the face. So obviously, that the circumstances of a homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Greg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where we're trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Mm-hmm. Yes, Your Honor.
That doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Gregg to. Then we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Gregg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Gregg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Gregg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the Monotone issue, really Gregg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court, and we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Gregg for both competence to stand trial and monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding in doing a monotone evaluation based on the fact that Gregg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Gregg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Gregg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct monotone evaluations, that Gregg said, no, we object to that, we don't want her evaluated, we're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under Monotone, Gregg did not object, and in fact, in the trial court, it asked, "Do you have any objection to the state's motion?" And they said, "No, Your Honor." So I think that any argument she makes that she should not have been evaluated under Monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being Monotone evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Murphy.
How much time do I have? May it please the court. I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole, irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing, and I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever's deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. But so there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure, prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of Section 4773 to sentence Johnson, who was 17 when he committed first-degree murder, to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, Section 97.3.21.2b allowed Carly Gregg's jury to sentence her to life without parole, consistent with Section 47.3.d, which is a parole statute, but only after it considered the Miller factors. However, the trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.3.21 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counselors. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection. And I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involve artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited by Justice King in Jordan v. State, by the Jersey Court in State v. Skinner, by the Ninth Circuit and United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Okay, thank you, Mr. Murphy.
And if there are no other questions by the justices,
no.
Thank you, Your Honors.
Ms. Hartman,
Yes, Your Honor.
Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. I would. May it please the court. So the majority of Gregg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403 whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that?
Yes.
I'm sorry. Where is that in the record?
Let me see if I have that written exactly down here. I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those 3 books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, and I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under Monotone, He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her not insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error, because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom, and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, "I messed up, don't call the police," things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under monotony. So, irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences. Thank you, Your Honors.
Thank you, counsel. The court appreciates your arguments and will take this matter under advisement and render decision in due course. We stand adjourned.
All right.
They will render a verdict in due course, or a decision. They'll render a decision in due course. What does due course mean? Months from now? Remember Shanda? She went just in front of one judge. We're still waiting to hear about her. So when you have six justices rendering a verdict or a decision, it could be a little bit of time. All right, I'm going to play one more final thing. Hopefully this will wrap things up for us.
A Rankin County team.
So this is a news clip. Let's see what these guys can help us sort things out here.
Being convicted of killing her mother is now filing an appeal. Thanks for joining us at 6. I'm Troy Johnson.
And I'm Megan West. Carly Gregg's attorneys were in court today. She was convicted of murder and aggravated assault in March of 2024 for killing her mother, Ashley Smylie, and wounding her stepfather, Heath Smylie. Gregg was 14 years old at the time.
The state Supreme Court heard arguments in the case today. 16 WAPT's Ross Adams has more from the courtroom tonight, where lawyers for the defense and the state squared off. Ross.
The argument centered around life without parole and life without the possibility of parole. Carly Gregg's attorney says unless she gets a lesser sentence, the 17-year-old could die in prison.
She's doing well. It's been a couple of weeks since I've talked with her, but she's in good spirit.
Rankin County 17-year-old Carly Gregg serving 2 life sentences in prison for the March 2024 shooting death of her mother, Ashley Smylie, and attempted murder of her stepfather, Heath Smylie. Surveillance video captured Gregg walking through the house after she shot her mother 3 times in the face. Gregg's lawyers argue because of her age, her life sentence in prison is unconstitutional. Gregg was 14 years old at the time of the crime.
Parole, it should be overturned, and either she should be sent back for another sentencing hearing, or the court, I think, has the option of just rendering a sentence of life with parole.
That's the argument James Murphy made before the state Supreme Court Wednesday after Gregg's conviction and sentence was appealed. Murphy told the court under state law, a juvenile can't be sentenced to life without the possibility of parole. Gregg was given 2 life sentences. In addition, she's serving 10 years in prison for tampering with evidence.
Now, by virtue of those 2 options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court.
Attorneys representing the state told the court the defense never raised any issues with the trial court. Justices, though, had tough questions about Gregg's life sentence, and some questioned if the jury got the right instructions on what that sentence means.
Life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole.
Gregg's attorneys argue that during the sentencing phase, they didn't have a chance to present any witnesses, and they only had between 7 and 15 minutes to make closing arguments. The judges on the court expected to make a ruling sometime in the coming months. For now, we're live at the State Supreme Court. Ross Adams, 16 WAPT News.
All right, Ross, thanks. Well, Carly Gregg shot her mother, Ashley Smylie, on March 19, 2024. Cameras inside the home recorded the sound of 3 shots and a scream, then showed Gregg walking into the kitchen, sitting down, and picking up her phone. During the trial, a psychiatrist testified that Gregg was in a mental health crisis and had multiple issues in the months before the shooting. After 2 hours of deliberation, the jury found her guilty on all counts. She was sentenced to life in prison. You can find every update on the Carly Gregg case, including today's court arguments, at WAPT.com. Also on the
All right, so it sounds like that little clip there, it doesn't sound like he's fighting for a new trial. It just sounds like it's just all about the sentencing, to give her an opportunity to at least have some hope of getting out at some point in her life versus just being in prison for the rest of her life without any possibility of parole. So that seems to be the crux of the argument, is like they're accepting the fact that she was found guilty. It's just more, is there going to be hope for her when she's in her 40s, 50s, 60s? Who knows? 30, 40 years from now, will she have the opportunity? So, all right. Well, we'll see. We'll cover it. We'll follow it. We'll see what the ruling is. It could be a couple months. Maybe. Hopefully, they'll get to it by the end of the year. And let's see. Life is the same as life without parole in Mississippi, Laura says. Debbie, isn't she into the kids' lockup? No, she's an adult. She was tried as an adult. JMS, I agree. They want to have her parole. I was just responding. To general comments. Gotcha. Right. Ronnie V, she has shown no remorse, and what she has done was horrific. She is dangerous. All right, you guys, I'm going to end this stream. We've got Carlos Dominguez. We're going to be starting in a few minutes. So I got to have a few minutes to get that stream started. So we will take this moment to say thank you for joining us for Carly Gregg, her appeal hearing. And this was good. This was a good little exercise to watch. You watch the in context, watch some of the trial, and then watch the hearing. And we'll see what happens. We'll follow it. We'll cover it. We'll see what happens. So with that, again, thank you for joining us. Thank you to our mods. Thank you to Aaron. We will portal you over to Carlos Dominguez. We are anticipating opening statements starting this afternoon, our time this afternoon. So in the meantime, we'll just go ahead and keep showing some previous testimony. But this is Carlos link. You will be portaled over. But here's the link just in case you are not. There's the link, but we're going to portal you over now. So whiplash coming, Kaylee. All right, Fur Baby's mom. Oh, Fur Babies, thank you for the buy me a cup of coffee and also the food that you sent. I know I sent you an email, but I just wanted to say thank you publicly to thank you for that. So Debbie, I hope you're feeling better after your surgery, and join us for distraction, join us over at Carlo. Okay, guys, we'll see you then. Which one is it? Not that one. This one. Okay. All right. We'll see you over there. Bye. Bye.